rise, my lords, only to say that our clients quite evidently aren't here. We don't know why they're not here. They may have got lost within the maze of this building.
Well, that's entirely...
We sent them out for lunch and said, try and be back here for 2 o'clock. They also told us that they may wander in at any point. I'm content to proceed in their absence in any event. They may come in at some point. They also told us over the break that they had anticipated this hearing would last not as long as it would do, and they have pre-booked a train back to Nottingham, I think they said at 3:30 or around that time, which means they need to leave at 2:30.
They may not come back then.
So I don't know.
Yeah.
So I'm content to concede in their absence, and if they do come back and leave, that is why they are going. I said.
Good. Well, thank you for it.
Hopefully the court will. Well, they can watch the proceedings back on YouTube, of course. I imagine their House content.
Well, these recordings remain on the web forever.
They'll be able to watch it back. Worryingly. Thank you very much.
Okay, well, while you're on your feet,
yes.
How is it that they don't have legal aid? What's the impediment?
As I understand it, it may be something to do with their means, but I've never entirely got to the bottom of it. They certainly were given an advice by me very soon afterwards saying they had merits, so I thought they had merits to...
And then we've got a decision by Lady Justice King granting permission.
I have tried to go in a back and forth between my client and the solicitor to try and work out why. As often as counsel, we don't really understand the workings of a legal aid agency, but in my understanding it's something to do with their means, but my client I don't think is employed. So I don't understand.
No. Well, I'm sure every effort's been made, but it just doesn't seem that in a case where they've had free legal aid, effectively, not means or merits, tested to get in front of the judge, and then a member of the Court of Appeal gives permission to appeal, and they don't get legal aid for the appeal.
As I understand it, it's still a means and merits test, even at that stage.
Right. Well, that's what I
when you've had permission, which is a baffling
there
situation, but that is.
Oh, thank you. Yes, Ms. Guha.
My lords and my lady, the foundation of this appeal is that there are a number of gaps in the extempore judgment that was delivered by Recorder Sanghera, and that these have led the recorder to err in law in 3 essential areas. Firstly, the failure to undertake a proper risk assessment. Secondly, to properly appreciate the changes that the parents had made. And thirdly, in undertaking a proportionality analysis. It's the position of the local authority that none of those grounds have substance when one scrutinises the judgment as a whole and the evidence that was before the recorder. And the recorder gave ample reasons as to reasons why he resoundingly rejected the parents' case, that A, they had shown a period of sustained change, and B, that the risks had been minimised to an acceptable level. If I can first turn to the challenge made to the risk assessment, I have addressed this in considerable detail in my skeleton argument at pages A54 to A56, and I was not intending to cover the same ground, but the areas of risk that were identified by the recorder in his judgment, I would submit, can be categorised as follows. Firstly, there were the findings of His Honour Judge Lee in 2013 in respect of the injuries that had been suffered to the mother's eldest child and the inability of the parents to accept those findings, to understand the risk that flowed from how those injuries were caused, and to show the relevant degree of insight to provide a foundation for change. And further, the assessment of the court and the expert, Mr. Marshall, was that this linked to the parents' inability to prioritise a child in their care over another relationship. The second area of risk identified, as highlighted by the Amber House residential assessment, was the overwhelming conclusion that the parents had been unable to adequately meet the needs of a child in their care and are unable to safeguard a child in their care, even when placed in a 24/7, round-the-clock supervised setting. Thirdly, there was the clear findings that the parents had been unable to be open and honest. And this was of particular relevance given that the parents were essentially accepting it's not safe for the child to be rehabilitated to our care without any support package. And we need professional support, but obviously if there was an overriding concern that the parents could not work openly and honestly with professionals, that support package would have no realistic prospect of success. Fourthly, there was concern on the part of the court and the professionals that about the father's ongoing aggressive behaviour, which featured in the incidents that were referred to by the court following the cessation of the Amber House assessment. And the final area of risk identified was the recorder's conclusion that the father had an ongoing association with drugs. And I intend to focus on the first and fundamental area of risk, which flows from the findings of His Honour Judge Lee. And as has already been pointed out by the court, the recorder gave extremely detailed reasons over several pages of his judgment as to why it was that he came to the overwhelming conclusion that the parents were stuck and that there was no genuine shift in their position, and they still did not accept that risk. And my lord, I just wish to take the court to some references as to what the parents' positions were about, for example, the third party at the commencement of these care proceedings. It is a fact that, for example, the mother took the third party to accompany her when she went to the pre-birth meeting in respect of this subject child prior to the issue of care proceedings.
Is that correct? I thought it referred to the fourth child. That was the reference that I had in mind. If you're telling us that it applies also to this child, I think you'll need to take us to
My lord,
to where that is said, or at least certainly take me.
My lord, may I check that reference? If you wish me to now, then I can. But I believe it was in Mr. Marshall's report. It may have been that I had misread that. But
well, can we leave that so that it can be clarified? But there's obviously a difference between what happened in 2017 and what happened in 2020.
Yes, of course. But my lord, there were several material facts that were reported during the assessment that was undertaken by Mr. Marshall in these proceedings, which included the father agreeing with Mr. Marshall that at that time of the assessment that the mother had not accepted His Honour Judge Lee's findings, and that was at paragraph 103 of Mr. Marshall's report. I think that's at C69 of the supplementary bundle.
69. Yep.
Yes, my lord. And the father also told Mr. Marshall, and this is documented at paragraph 101 in the report, that he had formulated the belief that the third party had inflicted the injuries to Chloe 6 months after the fact-finding hearing had taken place, which of course was in 213. And this was the bedrock to the recorder's analysis in essentially evaluating what the parents' responses had been to the third party when looking at the evidence about ongoing contact in 2020, some 7 years later, when the parents were at the Amber House residential assessment. And what the judge stated within his reasoning at paragraph 31, which is at A38 within the court's bundles, was that these were the comments being made by the parents when they were at Amber House. The judge says it further clashes with what she said at Amber House. This is second or third sentence, paragraph 31, when she referred to Mr. Kelly having done a lot for the parents and that they would never turn their back on him. It was referenced to owing her life to him and that she would never believe that he'd caused her daughter harm. Father going so far as to say he could guarantee it. This comment was made after the pre-birth assessment that goes against the father otherwise. He saying that he'd reached the conclusion about the third party some months after the findings were made. And, my lord, if one looks at the circumstances surrounding the evidence that the father had maintained contact with the third party whilst at Amber House, firstly, the evidence that was accepted and wasn't challenged was Amber House only found out about this inadvertently. When they did confront the father about it, he had in fact deleted the third party as a contact from his mobile telephone, therefore trying to conceal the fact that he had been in contact with this person. What's recorded within the judgment at A39 was that the father had said, well, there was nothing written down telling me that or prohibiting me from being in contact with this third party, insinuating that he was challenging the fact that he should have demonstrated the insight to have understood the risk himself. And this is a key example as to why the recorder reached the conclusion that he did, which is that the issues about whether the parents were in contact with a third party was not the beginning of the analysis or the conclusion, because what it signified is that 7 years later, there were still concerns about the enmeshed characteristics of the relationship between the three adults, and why it is that the parents had responses that they had. And if I could...
It was the local authorities' case, despite what you're referring to, that there was no evidence of contact between the parents and Mr. Kelly from November 2020 onwards.
Yes. There was no evidence to the contrary.
So the points made by Miss Limbury primarily, but also was Mr. Williams, that the judge took the position that you're describing and didn't take any account of the fact that there had been a significant period where there was a real change, because they had been enmeshed, the with Mr. Kelly at an earlier stage, but now there was no evidence of contact with him.
Well, my lord, the reason why the recorder, I would respectfully submit, did not address that issue in any detail, and he did not take issue with it, is because one has to examine the key finding he made at paragraph 18, at A35. And what the recorder said is that what the recorder was concerned about was that the clear evidence was that a considerable number of years after the court's findings, there is a clear lack of appreciation for themselves, for the parents themselves, that an individual who they now say must have caused harm to their child is not a desirable person to include in their circle. It is not the contact. It is the indication that this is a worrying inability to recognise risk and keep the child safe from harm from another, potentially risky individual. There is, therefore, an ongoing lack of understanding of risk. The parents have had many years to think about the harm that their child suffered, the consequences for them and their children as a result of proceedings that then ensued, whereas the phrase that has already been used in these proceedings, draconian. And the recorder goes on to clearly articulate why the parents' response in this regard was indicative of a far more pervasive and fundamental problem, in that the parents simply did not understand what the risk was that emanated from what they themselves had said and accepted in respect of the third party.
With reference to this issue of calling, the underlying material which led to this being part of your case is in the Amber House report, which is at C162, internal 351 of the supplemental bundle. An extremely long sequence of events which starts with people noticing the father, my words, not theirs, behaving in a strange way with his mobile phone. And then a long drawn-out process during the course of the day, trying to understand what had happened. It wasn't just the question of attempting to delete reference to the third party on the phone, but also to the third party having had a disguised name.
Yes.
On the phone, and that number of explanations were advanced by the father as to how all this had happened, that he was accidental calls had been made, and so on and so forth. But there we have the overall material, which led to what seems like a breakdown of trust between the residential assessment centre and the parents, because it was at that time, up to that time, there had been some positive features of the professional assessment there.
That's absolutely right, my lord. And as I understand it, there was no real challenge to any of those core facts, and that the father accepted that factual matrix. My lord, the question has been raised that the recorder did not identify precisely what the risk was. I would submit on behalf of the local authority that it was self-evident. It encompassed the entire spectrum of physical, emotional, and developmental harm. Not only in respect of the concerns about physical injury, but the ability of the parents to meet the emotional needs of the children, to be attuned to their needs. The Amber House residential assessment referred to a constant and recurring theme of staff members having to intervene to safeguard the child, and about their concerns about the child being left alone unattended, and which obviously correlates back to the findings made by His Honour Judge Lee about the lack of stimulation in respect of the eldest child. So the range of risk in this case was extremely serious indeed. And my lord, the argument presented on behalf of the parents was that concerns emanating from the 2013 findings were historic and static, but the judge recognised this at several passages of his judgment, at paragraph 38, but he deals with this in some more detail at paragraph 44 within his judgment. This is at A42. And the judge's reasoning is that the fact that some years have passed and risk has reduced over time is a generalism, quite often correct, but it only has material relevance when the circumstances that have arisen are such that the risk is capable of being considered. X is the parent's first child since the last set of proceedings. The response to someone harming their child can only be assessed by reference to the one incident involving the third party, and their attitude towards that held over many years, with an epiphany occurring apparently only very recently. I just wanted to deal with one more minor point at this juncture in respect of the submissions that have been made about the March 21 incident in respect of the father purchasing drugs on behalf of another individual. And the judge deals with this within the substantive judgment, the main judgment, at paragraph 23 and A36, and in respect of his comments during the request for clarification. And overall, what I would submit the judge's reasoning is that his abiding concern was that there was still an ongoing association between the father and drugs, and there was of course no reason for the father to have made the purchase on behalf of a third party, but the incident in fact went beyond that, as the mother had accepted that there was a verbal altercation with a person, and that's recorded at paragraph 23. And the evidence in respect of this incident can be found in the social worker's statement at B59, where it refers to what was reported in respect of the altercation, but in fact also documents that just after this incident it had been reported that there was a threat to kill made by the father towards the person who made the complaint. Now, of course, there were no findings about this incident, but the reason why I take the court to the primary evidence surrounding this incident, as it can't simply be minimised as a single isolated incident when the father had purchased drugs for someone else. There was evidence about the surrounding circumstances which the judge had heard, which caused him concern.
Well,
where is it in the judgment?
Yeah, that's exactly what I was going to say.
My lord, it's paragraph 20. My lady, it's at paragraph 23.
Well, where's the evidence about the surrounding circumstances that caused the judge particular concern?
What the judge said was the mother in her statement dated 7th of September 2021 accepted that the father helped someone get cannabis on more than one occasion. So that's where the reference to more than one occasion came from. And on 25th of March, a couple of days after this gentleman in Manuel House was helped to get cannabis, there is reference to what mother called a verbal altercation with this person. So the judge was in fact relying upon the mother's own evidence about this.
Sorry, where's the reference to the mother? That's the mother in her statement, accepted.
Yes, so the evidence came from the mother's statement.
That's still, it's all just the one occasion, isn't it?
Yes, yes. But when I was referring to the surrounding circumstances.
So what are the surrounding circumstances?
Well, I meant in terms of this was, I would suggest that the recorder was concerned about the drug deal that was undertaken in circumstances where there was also a verbal altercation, which would have had an impact on any child in the parent's care.
Thank you.
There were two separate days, 23rd and 25th of March.
Oh, I respect.
It's in the social worker's statement.
Yes. And the reference to the threat to kill was, of course, later. If I can now turn to the case that's been put forward on behalf of the appellants, that there have been significant and meaningful changes made by the parents, which was consistent with the period of sustained change that Mr. Marshall said was required. And this really was the cornerstone of the parents' case before Recorder Sanghera. And this issue does also link into the challenge made on behalf of the appellants that the recorder has inadequately dealt with the oral evidence that he heard. But the only specific reference that has been made by the appellants to any oral evidence given by any of the witnesses on this issue is really in respect of the expert, Mr. Marshall, in him saying that if the court was satisfied that there had been a year of sustained change, that of this, from a psychological perspective, would represent a change, and that it would take a period of 2 years for this to be deemed to be historical.
Understand Mr. Williams' case is that he got a list of changes, or it may be Miss Limbry, there's a list of the changes that have taken place, and these were put to Mr. Marshall and to the Guardian, and the social worker, Mr. Marshall and the Guardian, in cross-examination, and that there was a degree, substantial, not substantial, of acceptance by those witnesses that yes, there had been those changes.
My
So
lord,
it
of course,
wasn't just a global.
yes,
It
my lord.
was a specific, a set of specifics were put to the witnesses, and there was a degree of acceptance.
Yes, my lord, but a distinction has to be drawn between fundamental areas of risk that required change, and it was accepted by all the relevant professionals and Mr. Marshall and the judge that the parents had implemented what really were some lifestyle changes, and in improving their circumstances in terms of housing, employment, addressing the cannabis use. And of course, there was no evidence of ongoing contact with a third party. But one needs to really go back to the recommendations of Mr. Marshall to understand the genesis of why he was saying that a period of sustained change was required. And I would ask the court to look at his report at C80, paragraph 131.
Yes. 131 starts on the previous, bottom of the previous page.
Yes, my lord, if I don't just find the reference. So in respect of the father, if I could take you to the reference at the bottom of C79. Mr. Marshall said, together with Mr. Brown's severely insecure adult attachment style as reported above, there remains a significant risk that Mr. Brown will experience difficulties in recognising and thus responding to the needs of a child in his care. And indeed, until he has been able to demonstrate a sustained period of change, including in relation to substance misuse and responses to stress, there remains a significant risk that he is not able to prioritise the needs of a child in his care over and above his own needs. And the similar recommendation that was made in respect of Mrs. Brown, mother.
Could we try to?
I apologise. It's at paragraph 130.
Just on the one about Mr. Brown, first of all. This report by Mr. Marshall is written in January. Is it 2021?
It was
3rd of December.
December 2020.
And so that's what he said then. The judge is hearing it nearly a year later, and we know that there had been no evidence of drug taking by by the father for much, if not all, of that period. And so, presumably, in cross-examination, counsel for the father put to Mr. Marshall, "Well, you won't look for a period of substantial change, and there's no evidence of drug taking. What do you think of it now?" We don't know what Mr. Marshall said.
Well, my lord, if I may, I was going to turn to what we know about what Mr. Marshall said,
Right.
but I just wanted to look back at the original report, because what Mr. Marshall was saying in respect to both parents, and paragraph 130 has to also be examined in respect of the mother, because what Mr. Marshall says in that paragraph is that the mother had a number of difficulties which were explained by dependent.
Well, shall we, rather than you read it out, shall we just look at it ourselves?
Yes.
Yes. Yes, let's go ahead.
Yes, I was trying to find, there was another reference within this report to the expert saying why it is that sustained change was required, but I'm sorry, I just lost the reference. I just may have, sorry, a few seconds.
Is it paragraph 131, page C80, internal 269?
Yes, but I had originally thought it was 131.
That's
I
what
see
we
that
checked first,
relates
wasn't
to
it?
the
Yeah.
father and not the mother. And
Is the
yes,
bottom of
it's
page
in fact
132?
paragraph 132.
Yes.
Thank you. It's towards the end of that paragraph. I would ask the court to consider the extract starting, although there had been a change in circumstances.
Yeah.
And my lord, one examines what Mr. Marshall says in his oral evidence, and I've summarised that within my skeleton argument, A61, paragraph 38. What the expert said about a period of 1 year representing significant risk reduction cannot simply be looked at in a vacuum, and it has to be looked at alongside the other important aspects of his evidence was firstly that the fact that the parents could evidence some change did not negate the concerns surrounding dishonesty. And ultimately, Mr. Marshall was deferring to the court to make the findings as to whether the parents had evidenced the required sustained change. And he came back to the key issue, which is that there would still have to be a reassessment of the parents' understanding and acceptance of the findings of an AI to the eldest child. And the position of Mr. Marshall in oral evidence was, despite cross-examination, he maintained his position that the mother had not accepted the findings of His Honour Judge Lee and had prioritised adult relationships over her children. And a key aspect of Mr. Marshall's evidence was that there needed to be assessed change rather than therapy being regarded as the key measure.
So what's the reference for Mr. Marshall maintaining his view in oral evidence that the mother hadn't changed in her attitude towards Judge Lee's findings?
My lord, this is all being extracted from the written submissions, closing submissions of the local authority.
Right, so just for my
C.
note, what page is
C239
Thank
to
you very much.
240. And my lord, it's at the end of the second paragraph on C240.
So the second paragraph.
On C240, he maintained his view that at the time of his assessment, the mother did not accept findings made in 2013.
Okay, thank you.
My lord, therefore, it would be my respectful submission that when examining the parent's case about...
No, I'll just read that. He maintained his view that at the time of his assessment, Mrs. Brown didn't accept the findings made in 2013. So what you were saying was that in evidence, Mr. Marshall maintained that the mother had not changed in her attitude to Judge Lee's findings. So I should add in my note, at the time of his assessment.
Yes. And of course, the finding of the court, for reasons that were explained in detail, was that he was not convinced that the parents had a genuine and full acceptance of the findings that were made. And it would be my respectful submission then that when looking and examining the parents' case on change, it's not enough to simply examine the lifestyle changes that were not in dispute, but to look at the core risk factor, which was the fundamental area of concern, which is whether for a sustained period of time the parents had demonstrated an understanding and a change in approach to the findings that had been made by His Honour Judge Lee, and why there was a risk emanating from what had been found by the court to have been their response to what had happened at the time.
Thank you.
And my Lord, I said that this ties in to the challenge made about the failure of the court to deal with the oral evidence in any detail. My Lord, this challenge does not have any substance, given that it has essentially been accepted that the key professionals, in particular the social worker and the guardian and the expert, did not significantly change their recommendations or their assessment in respect of the risk. The position for the social worker and the guardian remained that they ruled out rehabilitation to the parents as too unsafe and presenting an unmanageable risk for the child. And Mr. Marshall's risk assessment also was not dented by cross-examination. And therefore, this complaint about the lack of detail in the judgment does not ultimately have any substance, because it cannot be demonstrated that there was any key oral evidence that was simply ignored or disregarded by the judge in formulating his analysis and arriving at his ultimate conclusion.
All of these submissions are about the parents' case, that there had been significant and meaningful change. You started your contribution on these submissions saying this was the cornerstone of the parents' case before the recorder. Where in the judgment, and it may well be, that's not a loaded question, but where in the judgment do we find the judge engaging with that cornerstone of their case and dealing with it?
My Lord, there is reference within the judgment to recorder referring to the fact that the parents had said that material changes had been effected. Firstly, at paragraph 30 on A38, and I believe there is another reference.
Well, it's a reference. It's paragraph 30 is the parents' position is that they have made and sustained changes. Sadly, the evidence I've heard over 4 days, followed by written and oral submissions on a further day today, has proved scant evidence of this. And then he gives some examples.
And in particular, the recorder refers back to his overriding concern about the parent's attitude to the findings made by His Honour Judge Lee. And my lord, that's why.
It's 30 and 31.
And this feeds back to the submission I just made, which is whether it is a correct interpretation to say that the expert, Mr. Marshall, was saying that cosmetic changes to the parent's circumstances and lifestyle needed to be demonstrated. And that's all that was required for the relevant risk factors to be mitigated in this case. And in my respectful submission, that simply was not what either Mr. Marshall was saying, or and this was not what accords with the analysis of the recorder as to what the primary and fundamental areas of concern were in his risk assessment. My lord, if I can now move on to the challenge to proportionality, and I wanted to briefly refer to the case of Re R, which is in the bundle of authorities, which I hope the court has.
So do I. My lord sent it to me. I can find it. Yep, there we go.
If I could first ask the court to look at electronic page 47, paragraphs 18 and 19 of the, I believe it's the judgment of Lord Justice McFarlane.
Ah. So this is Re R 2015. So paragraph, sorry.
18 and 19.
Thank you.
And as was commented by Lord Justice Jackson earlier, the key factor for the court to examine is the structure of the analysis, rather the substance of the judicial analysis, rather than the form and the structure. And the facts of Re are, of course, similar to this case as a result of the fact that Recorder Sanghera was essentially faced with a binary decision himself. That the two options that were being viewed as the realistic options were either rehabilitation to the parents or an adoption care plan. And I'd also ask the court to look at paragraph 60 and 69. And there was a reminder at paragraph 60 that in its analysis, the realistic option of the child's future, this does not require a court in every case to set out in tabular format the arguments for and against every conceivable option.
Sorry, wait. That's paragraph 60
Yes,
of RER.
it's a citation
I've gone too far.
from a decision of Mr. Justice Baker, as he then
So-
was.
56, page 56.
Done with you, yeah. Yep, thank you.
And finally, I'd ask the court to examine paragraph 69, where guidance was given by Lord Justice Munby.
But just pause there. What then Mr. Justice Baker was saying is rigorous analysis and comparison of the realistic options for the child's future doesn't require a court in every case to set it out in tabular format, the arguments for and against every conceivable option. Such a course would tend to obscure. This is part of the focus on reasonable options, but you must accept, mustn't you, that Mr. Justice Baker was expecting that there would be some comparison, his word, of the realistic options.
Well, in this case, it is evident from reading the judgment as a whole that the recorder was scrutinising the positives and the negatives of a placement with the parents. But the recorder came to the resounding conclusion that a placement would be so unsafe and there was no framework under which that it could
So
happen.
if that's what the recorder did, he looked at the positives and negatives of a placement with the parents. How is that a comparison between placement with the parents, positives and negatives, and placement for adoption, positive and negative?
Because within the recorder's judgment, in the body of the judgment, the court is clearly focusing upon its determination as to whether it be safe for the child to be rehabilitated to the care of his parents. And the recorder does expressly look at all the potential permutations of how that could happen, whether there were any support services that could be put in place to buttress such a placement. And the recorder evidently came to the conclusion that that was not viable in this case if the parents weren't able to parent to an adequate standard in the highly supervised residential environment. And when I would submit that in paragraphs, particularly from paragraphs 40 onwards, that the judge is undertaking a proportionality analysis in weighing up the feasibility of both options.
Sorry, the paragraph which onwards?
Paragraph 40
Thank you.
onwards. And for example, at paragraph 40, the recorder reminds himself of the dicta of Mr. Justice Headley in the case of Riel, which, and the message being delivered by Mr. Justice Headley was that society had to tolerate very diverse standards of parenting, and which was obviously emphasising why it was so important for children to be brought up by their natural parents, if at all possible. And there are other references within the reasons which demonstrate that the recorder was very alive to this principle and the disadvantages that would ensue from the severance of the relationship between a parent and a child if an adoption order was made. And therefore, it was integral to that evaluation, I submit, that the seeds of the proportionality analysis are there. And the reason why I was taking the court to...
So what, I'm sorry to be pedantic about it, but what are the references in the judgment you just made reference to, where the judge does go and look at the negatives of adoption and does display at least the seeds, as you say it, of the proportionality exercise?
Well, my lord, I think if we start at paragraphs 47.
Thank you.
Where the recorder highlights the consequence of adoption being that adoption severs all family relationships, making him a permanent member of the adoptive family to whom he then belongs. At paragraph 48, there's further analysis of what the impact would be on the child, including that an adoptive family, well, that would be a benefit of feeling different from being in long-term foster care. And this is really analysis of the differences between adoption and long-term foster care, but there's a recognition that there is that some adoption placements do fail. And for example, one of the disadvantages of adoption is that the parents would not be able to apply for a care order to be discharged. Another potential disadvantage would be that contact is minimal.
Yeah.
And at paragraph 49, looking at the guardian's evidence, the judge considers the positives of the commitment and love of an adoptive placement. And therefore, I would submit that the judge had grasped the fundamentals about why an adoptive placement is so draconian, and it simply wasn't a tokenistic reference to the fact that this is the most draconian form of order, and in making reference to the yardstick of necessity and proportionality, as highlighted by BS, this reasoning demonstrates the recorder understood what that meant.
What do you say about paragraph 50, where he deals with parental consent? Is that a satisfactory description of the exercise?
My lord, I have to accept it's an extremely summary reasoning that's been given. The judge identifies the right test, which is whether the court is satisfied that the welfare of the child requires it.
But he says, in this case, I presume neither parent consents, and to give the order that I'm making today effect, I dispense with the parent's consent. That's not the reason to dispense with consent. That's the cart before the horse, or whatever it might be. He should be deciding that it's necessary, or that the child's welfare requires adoption before he can dispense with consent. He can't decide to make the order today, and in order to give it effect, dispense with consent.
Yes. My lord, I would suggest, though, that the reasoning that precedes that paragraph does set out why the court came to the conclusion that the child's welfare was commensurate with an adoptive placement.
Isn't, under this scheme of legislation, there isn't really a gap between a welfare conclusion and the dispensation with parental consent. I mean, there used to be the whole argument about adoption was a big gap between those two, whereas I may not put this correctly, but in essence they're two sides of the same coin. Putting it another way, one couldn't find that adoption was necessary, but not proceed to make a placement order because the parents didn't agree.
Yes. Yes.
You might, before Re B, where nothing else will do, came in, you might intellectually think in a case that just on balance, welfare might favour adoption, in which case there might be a gap between that and what's required for dispensing with consent, which is that it requires adoption. And it's that comes in that provides that nothing else will do. It's the some reason in my head I've got the Spice Girls hit, but it's what the child really wants that triggers adoption. But now, as my Lord says, and I agree with him, now the welfare evaluation requires the court only to favour adoption if nothing else will do, if it's necessary. Once you've answered that question that way, then the answer to does the child's welfare require adoption must be yes. It could not possibly be no, or anything else, or I don't know.
I mean, certainly the second last sentence should have found its place earlier in this short paragraph.
Yeah, but that may be just being pedantic.
Yes, my lord, and a lot of the criticisms, which some of them may be found to be valid by the court, they all really do relate to the structure of this judgment rather than the substance. And to complete the submissions I made about the proportionality analysis and weighing up the positives and disadvantages of the options, one other reference within paragraph 41 of the judgment was the fact that the judge, of course, recognised that this child, who was too young to express any wishes and feelings, the judge accepted, no doubt, as with any other child, would wish to be brought up by his parents.
The judge is sort of working his way through the welfare checklist without signposting it.
Expressly doing so, yes.
Could I ask you this, Ms. Kuha? As it seems to me, real thrust of the appeal is to challenge your submission that this is all just a question of structure and that it could have been better expressed, could have been put together differently, but you say it's all in there, or enough is in there to justify the discretionary decision, even on such an important matter. What's being said, as I understand it, is, amongst other things, that really the judge so understated the parents' case for change that in the end they don't really know why they lost, because he didn't fairly set it out and fairly deal with it, and that they're left thinking, well, once we got the negative reports, we didn't have a hope at that point. Now, what's your reply, if you have one, to that theme?
My lord, my response would be that it cannot be said that this is a judgment which is so defective because it contains no reasoning whatsoever and contains no analysis whatsoever of the evidence and contains no findings.
Well, you're setting yourself quite a low bar there. Clearly it contains some analysis, some findings, and some reference to the evidence, but really the gist of the appeal is that the judge didn't confront the parents' best case. Is that a submission that you
My lord,
say something about?
I would suggest that's not a tenable criticism that can be made when one examines the detail of the reasoning of the recorder for the reasons I've already submitted earlier, which is that the recorder's main concern in respect to risk revolved around His Honour Judge Lee's findings and the inability of the parents to affect any genuine shift in their position in the passage of time, and that although the parents were showing a change in that they were no longer actively denying the truth of those findings, although there was some suggestion of that, because, for example, when the mother was assessed by Mr. Marshall, she was still referring to the elder child playing outside, suggesting that there hadn't been deliberately inflicted injury. But the recorder clearly found that the parents may have been expressing different sentiments about those findings, but his clearly concluded view was that they were just mouthing the words, having taken legal advice. And I would submit that the interpretation of this recorder's judgment can only be that in circumstances where previous courts had made decisions and findings with respect to their previous children, this recorder was saying essentially that nothing had really moved on.
Do we know how long the parents gave evidence for?
I'm afraid, not being
I'm
the
sure
trial
Mr.
advocate,
Williams knows.
I don't have those details. My Lord, are there any other issues that I can assist the court with?
No, thank you, Ms. Guhan. Thank you. Yes, Miss Moore.
My Lord, your Lord, my Lords and my Lady, you've heard detailed submissions from everyone, perhaps now except for me, and I don't want to go over ground that Miss Guha has gone over on behalf of the local authority, because although I look at this judgment through a slightly different lens to hers, because I'm representing the child and not the local authority, there are no substantial or significant points of difference between us in terms of both what the Guardian invites the court to do, but also the broader approach to the judgment itself. My Lord, may I say that if I'm being in any way unhelpful or going over ground that I don't need to assist you with, then I would certainly be very grateful to be made aware of that, as I'm conscious of the time in court. My Lord, the Guardian is very concerned about delay. I know that's not a central issue in an appeal such as this, but from the child's perspective and experience, he is now 18 months old. He has been recognised already previously today, been in proceedings all of his life, save for I think the first 2 days. He spent a short time in foster care whilst the residential assessment was arranged. He then spent some months with his parents in the residential unit at Amber House, and then, as is clear from the papers, has been in foster care for the last 14 months. The Guardian is, of course, mindful that the decision that is made for him and his future must be the right one. It must be based on solid evidence and sound reasoning. But he is, as I say, very concerned, as in my submission he must give account of. He is concerned about the delay for this child. My Lord, the Guardian invites me to stress that when he was allocated, and he wasn't the Guardian in the previous proceedings, he became new. And he was absolutely clear in his thinking at that point in time, at the beginning of proceedings, that the right approach to assessment was of risk was the combination of psychological assessment and the residential assessment. And my Lord, as set out...
And it was he who pushed for the residential assessment.
He did. And in fact, a little further down the line, when things were looking positive, he was active in voicing the need to look ahead, to think of accommodation at the conclusion of the residential assessment, of support and future planning. Unfortunately, the way that the assessment evolved, it was not a positive outcome. But he certainly, during the assessment itself, was very vocal on this child's behalf to make sure that if at all possible, the parents and child could move into the community as the next stage of their assessment. He was left, my lord, as you'll see from his final analysis, sadly concluding on the basis of the evidence that he could not support the child being rehabilitated to his parents' care. He acknowledged in writing in my submission, but also we're told in cross-examination, he acknowledged the positives and what the parents had been able to address, but in summary, he was very clear in his evidence that whilst giving the appropriate credit that any guardian should give to parents who've taken steps to improve their situation, nevertheless, it was too early days, and the changes did not go to the heart of the safeguarding issues that had been the subject of the previous proceedings, but it also then the same themes re-emerging in the Amber House assessment. So that was very much the Guardian's position. I don't accept that his report did not balance options. It's, of course, at B90 in the bundle. In my submission, it clearly does, on reading, set those out and does give the parents credit. That is not undermined by his ultimate conclusion that he could not recommend rehabilitation, and having considered the options, he favoured adoption as the only realistic option for this child. Can I turn to the issue of transcripts, which was raised before the luncheon adjournment? On instructions, I take no issue with the council's notes of evidence such that there is, that has been put before you in this appeal.
Well, those are the closing submissions.
Yes, yeah. Yes. Although I note that my instructing solicitor primarily drafted her submissions as a summary of evidence that have been given. My lord, I will accept that when I first saw the papers, it immediately occurred to me that I needed to consider whether transcripts were necessary. I'm not going to stray into giving evidence. At that stage, there was a technical problem due to the legal aid certificate, and it was simply not possible. And in fact, on my instructions, not yet possible to apply for transcripts of evidence. And that's the reason that it comes before you today with this conundrum and this issue. I can explain further, but it perhaps isn't necessary at this stage.
I'm speaking only for myself. This seems to have rather gone into the background during the course of the day, because we've been looking at all the issues without finding ourselves in a situation of embarrassment from not knowing who said what when. Of course, as was well expressed, it's harder to give colour to submissions when you don't have a transcript, but we don't have transcripts in every case.
No.
But I'm not sure what particular issue now arises that we're unable to deal with because of
well, my lord,
the transcript.
Can I put it this way, given it further thought over the luncheon adjournment? If the Parents' Council had identified and set out a note of evidence in support of their case that was significant and undermined the findings that the Recorder and the conclusion the Recorder ultimately came to, I accept the situation may be very different. But my understanding is the colour point put aside, the detail point put aside, it's not clear to me that there is a significant piece of evidence which it suggests was given as all evidence, but that goes to the heart of the decision that the Recorder was charged with making. Certainly on behalf of this child, the concern is that if transcripts are obtained and the delay that will necessarily follow, there is the risk that the court has before it more evidence that confirms the decision that the Recorder reached. I hope that line of thinking.
Right, you say that if it is almost unthinkable, as it were, that we were now to stop and to start again with transcripts, that the likelihood is that wouldn't help the appeal at all,
Yes.
in the light of the fact we haven't alighted upon a point that's an issue in favour of the appeal.
My lord, yes, to be blunt, but I hope not rude, if, for example, it was suggested that Mr Marshall in evidence had changed his mind on many features, I'm confident that that will be before the court, and that would make a very different situation to the one which is being considered this afternoon. Turning back, if I may, to the totality of the judgment, I accept in my skeleton argument that there may be remarks that may be said about the structure of this judgment, in particular perhaps an absence of headings.
Okay, can we, I'm just looking at it again, and I didn't tax Miss Guha with this because I didn't quite see it in the way I'm suggesting now, so if she wants to come back. Looking at the structure, if we go to paragraph 39, where the judge moves from summarising the evidence and the factual background. So 39, plainly accepted law, no jurisdiction, less threshold. So he's doing threshold there, and then he recites what the threshold is, and then he finds in the middle of that paragraph, threshold is satisfied. That, of course, is not conclusive of the case. Once those criteria are established, I have to consider whether an order should be made at all, and if so, what type. In those circumstances, I have to apply the welfare checklist. Now that, it seems, because he says consider the welfare paramount consideration, that he's deciding it under Section 1 of the Children Act. He then goes on, as we know, to quote Mr. Justice Headley, paragraph 41, the realistic options are parents, foster care, or adoption. He then summarises the factors over the next few paragraphs. 45 deals with the question of adjournment. And then 46, having seen and heard the witnesses, I'm convinced the parents have shown they're simply not able to care for their child. Placement of the child with the parents is not an option, particularly when balanced with the other foster care and adoption, full stop. So that is where he's ruled the parents out. Now, it might be said that was all conducted within the context of Section 1 of the Children Act and not the Adoption and Children Act. He then goes on, the adoption of the local authority's plan is to place for adoption. I have to consider the welfare checklist under Adoption Act 2002, but by then he's ruled the parents out. Is it a concern that we should have that a judge hearing a rolled up case such as this, where the issue is placement with the parents or adoption, should conduct one welfare analysis with the Adoption and Children Act welfare requirement throughout his life there, and the welfare checklist under the 2002 when making that choice, and not compartmentalise it as it seems the judge did?
My lord, I pause because, of course, it must be right to consider the parents first. That must always be the first option.
But not, well, the danger of doing that is it's a linear process. You consider them first, knock them out, and then the only skittle standing is the other one.
I understand that point, of course, but my submission is one would, of course, expect the judge to start with a approach that the
Well,
child...
just to take it in stages, really it's a ballpark question. If I'm right in looking at this and saying he decided the whole question of placement with the parents under the umbrella of the Children Act welfare approach, full stop, before going on to consider adoption after he'd ruled them out, is there a difficulty in law with that approach?
Well, I don't think so, particularly in the circumstances of this case, where he made such a clear finding that, for example, paragraph 46, although it's not the first statement of it, I am convinced that the parents have shown they are simply not able to care for their child. Placement with Ethan is not an option. And as part of that sentence, he is considering adoption. So, my lord, in my submission, although it could perhaps have been more elegantly expressed, the way he deals with it is not, in my submission, fatal to the decision-making process.
So he considers the parents under both statutes?
Yes.
Or if not, then the two are considered cheek by jowl to such an extent that it wouldn't be right to say it was compartmentalising. And I'm just seeking
Yes.
to draw out what you were telling us.
My lord, yes, and I thinking, of course, on my feet to what sense it makes sense to go back round it separately for adoption, having made that very clear finding in terms of placement with his parents.
Because the stakes are higher, the issue of the welfare requirement is different.
Well, my lord, in my submission, this is a rolled up consideration of both, paragraph 46 that we're looking at.
Thank you. Yeah, thank you.
So well, I ventured into the the structure of the judgment, and I do accept that it would have been helpful if this judgment had been better structured.
In terms of headings, it's an extempore
It is.
judgment. So one is not overcritical of matters of felicity that might have gone into carefully crafted. I mean, it takes 10 times longer to produce a reserved judgment than it does to prepare an extempore one and just get on and deliver it.
Yes. In my submission, you've been taken to, and I doubt will assist if I go back over it again, but the clear analysis of the parents' case that the recorder undertakes, looking specifically at their case in terms of change. And whilst, of course, Mr. Marshall's report comes in December 2020, that the evidence that the judge heard from the parents was at the final hearing, and that was his window into their insight, perception, understanding, their case about the findings at that very final hearing. And in my submission, he was not only entitled, but really it was his duty to pull all of that together, and he was entitled to make the findings that he did in terms of having heard their evidence, put that together with the other evidence before him, that he was not persuaded that their case in respect of insight on the one hand, insight in particular, and understanding, and that inevitably leads to their capacity to safeguard their child, that he wasn't satisfied that there had been movement, and certainly not the improvement that there would need to be to enable them to resume his care in a safe and good enough way.
Was it also his duty to set out their evidence so that ultimately they could understand why he was rejecting it?
I accept that it would have been helpful to them if he had set out more of what they said.
Fair to them?
My lady, I'm sorry, I didn't hear.
Fair to them?
My lady, I'd accept that. And I also, the judgment must be fair to the parents so that they understand, but also fair to this child who,
Yes.
in the future, will need to and have the right to understand why decisions were made about his future, the most draconian decision, of course, that can be made. And in my submission, whilst there are legitimate criticisms of this judgment, when it's taken in the round, it does sufficiently set out, in my submission, the issues and the reasons for the decision. And in my submission, the order that the recorder made was not wrong on the evidence that he had, even considering the issue of transcripts of evidence. I don't invite the court to adjourn to obtain transcripts. I do invite the court to dismiss the appeal and uphold the order. Can I assist you any further in terms of any other matters?
No, thank you, Ms. Moore. Thank you. Ms. Guha, do you want to come back on the point that I put more crisply than I had thought of it before?
Yes, but I think what I would add is that there would have been an error of law if, in the proportionality analysis, the judge had not considered the disadvantages of an adoptive placement for this child at all, because what I would suggest was underlining the determination in the line of cases starting with VBS was that a court, in looking at an application for a care order with a care plan of adoption and a placement order, could not simply rubber stamp adoption because it ruled out parents, and what a court had to holistically evaluate was the inherent disadvantages and disadvantages of both options. But the judge has done this in this case. He has been alive and alert to the potential disadvantages of an adoptive placement for this child. And my Lord, if I could just come back on one other issue, Your Lordship was absolutely right.
But by then he decided that there was no other option. And he initially, when I read, I think it's Mr. Williams, it may be someone else, had said this wasn't just a linear judgment, it was a polar judgment. And having now seen that the judge may well have determined the option of placement with the parents under one statutory regime and then the adoption issue under different, you can see more readily that these were dealt with separately.
My Lord, I would suggest that's why I suggested reading paragraphs 40 onwards, shows that the judge had considered all the relevant issues, perhaps not in the right places, and structurally there are valid challenges that can be made.
Well, there is a real danger of this court being hung up on structure and missing the substance. But the structure has developed and been put out there for use of judges in order to ensure that the correct issues are brought together and balanced against each other in one overarching, holistic, whatever phrase you want to use, welfare evaluation. And I really struggle to see where the judge did that in this judgment.
My Lord, that's why I thought it might be useful to look at the guidance of re-art, because that really flagged up that in a case such as this, it was a binary decision because there are only two options. And I think, as has been said earlier today, the judge did have to commence by looking more closely at the option of rehabilitation.
But in re-R, and it's a different case, obviously, but in re-R, looking at paragraph 18 and 19 you took us to, danger of casting a single judgment into a linear simply because of matter of structure, which is quite right. Everything has a beginning and a middle and an end. In the present case, with two options, the judges face the binary option. Third evidence. Hang on. Yes, the entirety of his judgment, including the analysis under Section 1.4 of the 2002 Act, is entirely engaged in analysing the positives and negatives from the point of view of the child of that option, looked at as a whole, which is the perspective that must be applied. It's not possible to say the judge compartmentalised his analysis. Well, can that be said of this case?
My Lord, I would have to adopt the submissions that were made of my learned friend that this was a rolled up analysis, essentially.
Yeah. Well, you have to say
yes.
The difficulty is that one doesn't start a judgment with without any idea what one's already decided, and the trouble about not having a proper structure to a judgment, even if it's an extemporary is that you can identify your decision at various points during the course of the case, the course of the document. And I mean, sometimes for particular reasons, the judge gives the outcome of the case at the beginning of a judgment, and then goes on. That's for perfectly understandable and different reasons. But once one doesn't have a structure, you can end up having this argument about whether this is a rolled up conclusion or a compartmentalized conclusion. And there you have it.
My Lord, I think the main thrust of the submissions that have been made today are that this is not a case where the judge simply paid no regard to the relevant principles. He had them in mind, but the ultimate conclusion that this court has to draw is whether he erred in law in his approach to the balancing exercise.
Finally, I didn't ask you, if the appeal is allowed, what do you say that the order of this court should be in terms of whether there should be a rehearing or whether this court should in some way, nevertheless, as you would say, not set aside the order?
My Lord, well, the question arises, if the appeal was allowed, whether a transcript of the oral evidence should be obtained for...
Well, that'd be too late for this. If the appeal were with, another option is to adjourn to get the transcripts, but I don't feel there's much engagement in that as an idea, because we haven't really mentioned it.
But if the appeal is allowed, is your Lordship asking me whether...
One option might be if the evidence was so clear that the only order that could be justified at the end of a particular hearing was X. The judge made X, but the judgment was not sustainable. The court could nevertheless, the appeal is against the order, the court could take the view that it was just not necessary to go through the process of sending it back to be reheard, because the answer again would be X.
My Lord, I would...
Seems to me there's difficulty in maintaining that view here, where we've got the missing part of the jigsaw, which is the oral evidence. It's difficult for us to say the answer must have been X adoption, where the counsel for the parents are submitting that there was oral evidence, which would have brought that into more question than might be the case on the papers that we've got.
My Lord, there was a difference in approach in this regard, and I think it was accepted on behalf of the mother, for example, that the summary of the oral evidence did provide the court with sufficient information in respect to the key passages for the oral evidence. So if the court agreed with that, and that's certainly the approach I take on behalf of the local authority, then
we've got enough information if we felt
yes,
this was the
well,
case
the court will have to
uphold the order nevertheless.
Well, the court will have to take a view on that, but absolutely the resounding position on behalf of the local authority is that when looking at what the potential outcome could be in this case, there is only one upon the evidence and the findings made by the judge.
Thank you.
My Lord, I just wanted to come back on the query that was raised by Lord Justice Jackson. That's right, I found the reference, C71, it was 2017, so it was an eldest child in respect to the pre-birth meeting. Thank you.
Thank you. Now, I don't know which order we go, but Ms. Limber, Mr. Williams, do you want to make any submissions in response?
Good, yes. Just on that last point about the approach of the court, I'm in some difficulties. I have an advantage of knowing what was said at the previous hearing, but a disadvantage because I can't use that information because I can't give you evidence in relation to it. So I'm trying to be cautious of. If the court is concerned about the judgment, I would submit that the appropriate course is either to get a transcript of the judgment and then consider the basis of that, or to remit the matter for a rehearing.
I think that makes sense.
Yes, but they're not. These are not symmetrical ideas, because a transcript of the judgment freezes.
Transcript of the evidence.
Sorry, I know. I said the transcript. Misspoke. Transcript of the evidence freezes things as they were in November, whereas a rehearing would be a live event, which probably, now that we're in March, wouldn't take place for some considerable number of weeks.
Well, if it was
Months,
going,
I would have thought, in the Nottingham list.
if it was going into the ordinary list, it would be the autumn in most places.
Yeah, I've got a
July.
case in Nottingham listed into July.
Yes, I know we haven't explored, although in the trial bundle there are a huge number of case management orders, by which one sees that the case moved into different trial windows and moved out of them and went on and so forth. And so that gives you, as it were, an insight into what was going on in the court, at least last year, in the normal way.
So it certainly wouldn't be before, in the normal list, would not be before
No,
July.
we'd have to.
List at the moment, maybe even August.
Did you, while we're on practical matters, have any recollection of the length of the parents' evidence?
I've got the witness template, which suggests that both of them were due to give evidence for about half a day each, and I don't think we slipped that far from the witness template. So sort of 2 hours each. The majority of the cross-examination was by the local authority representative.
Did you have other?
I did have some other submissions in relation to other matters raised. With respect to the analysis about adoption that the court was just challenging there, I think the court has made points to the other advocates would indicate a view, but the court can't carry out an analysis of adoption against the parents if it's already said that the parents aren't an option, which I think is the point that my lord is making. Similarly, with respect to structure, it is important because it allows the proper application of the legal principles. We're all saying that the structure could be better, but it is what it is. The problem with the structure in this case is it doesn't appear to have properly applied the legal principles to it, and that is why it is there's a deficit there. With respect to the threshold, my lord asked questions in respect to the threshold in this case. My understanding, having read through the various documents, both in the old bundle and the newer bundle, is if my lord has the original bundle, my client responded to the local authority's, inverted commas, final threshold at A64 of that bundle to A66.
Yes, I read that. As you said, she accepted some, she didn't accept others fully.
The father never responded to it, but Miss Gilead helpfully in her submission sets out the father's position with respect to those in the supplementary bundle that you have before you now, and if I just turn those up, those are on C223 of the supplementary bundle. She says in 4 lines, father has not filed a formal response. Items 1 to 4 are based on previous findings and are conceded. 5 and 6 are welfare, not threshold, and item 7 is a repetition of item 1. The local authority's document and the local authority advocate didn't make any submissions in addition to the document. Simply says, and I think these are the closing submissions on C229, court is respectively referred to the final threshold, sets out the findings sought by the local authority. It is not an agreed document. They then go on to submit that the threshold is crossed. So there was no invitation to make those numbers 5 and 6 from the original document, which, given my lord's got it, I won't seek to make it available to everyone else unless you so wish to have it as a separate document. It may be of benefit, but it was never dealt with by the judge in the judgment.
And in the order it just said the threshold is crossed.
Indeed. So it can only be realistically on the basis of those first 4 points, given those were the acceptances by the parents, and there was no findings obliquely made within the judgment itself, and there were no acceptances of them by them. So that deals, I think, with the queries raised with relation to threshold. Other queries have been raised in relation to the factual matrix about 23rd of March. The mother's final statement is in the bundle, which deals with that incident. And again, I'm not clear as to why the judge comes to the view that there were multiple occasions that the mother accepted, because at B, this is in the supplementary bundle, B64, the mother's final statement says in paragraph 7, in relation to the incident on the 23rd of March, these allegations may concern him. However, I accept father helped this person get some cannabis. There's no reference, as I see it, to a second incident or a second incident of obtaining of cannabis, and there's no other references to evidence in relation to that, which I think was my lady's question. The other incident is on the 25th of March, where it was her, the mother, who was said to have engaged in a verbal altercation between herself and a service user. That's paragraph 9 of B64 of the supplementary bundle. Comments were made by my learned friend for the local authority with respect to what Mr. Marshall was referring to with respect to sustained change were lifestyle choices. When the court looks at Mr. Marshall's document, the reason the question was put to him about what do you mean by sustained change is it relates to, on C80 of the supplementary bundle, cannabis usage, so significant sustained change, with cannabis use. It also relates on C80, so I'll draw these up and just give proper references. C80, at the top of C80, in paragraph 131, relates to sustained change, relates to cannabis use. Further down that page, there's another reference to sustained period of change in relation to Mr. Kelly, in paragraph 132, so a separation, the third party. Similarly for the father, with respect to the third party on C81, and then there's references to drug services and engagement with those by way of sustained change on C82. So those are the matters that are linked to sustained change within the report of Dr. Marshall, and those are the matters that he was saying needed to be addressed by way of work. I don't think...
Sorry, I know you're trying to deal with this quickly, but the paragraphs are there to be read, and it's not just about the points you make.
I entirely...
There are other points that are woven into those.
I entirely agree with that. It's just in relation to the wording of sustained change. That is what he was referring to with respect to the various issues. I don't think I had any other matters that I wanted to raise, other than you asked me earlier, my lord, in relation to whether there were other matters in relation to Mr. Marshall's summary that's in the local authorities document. There were a few, when I look back on my notes, that would be of benefit for the court to see, but the difficulty is how I tell you those without telling you what they are. And I'm not going to do that. But there were certainly ones that are in bold in my notes, so I'd be struggling to see how I hadn't referred to them as points that I thought were relevant. But without a transcript, I can't go any further than that, unless I can assist you further.
No, you've been very helpful. Thank you, Mr. Williams. Ms. Limbury, anything you want to add?
Only very briefly, my lord, and it's this. I do maintain this appeal is based on substance being the problem with the judgment and not form. And I rely in particular on the points that my lord raised as to whether the parents, on receipt of this judgment, were actually able to identify why they hadn't, well, not why they hadn't won, but why they had lost, given what had come to pass during the course of those proceedings. And my learned friends rely on the well-known case of English and Emery Reinbold. I would draw the court's attention to page 393 of that judgment, which is page 67 on the internal references. And there it's stated, we would put the matter at its simplest by saying that justice will not be done if it is not apparent to the parties why one has won and the other has lost.
Which paragraph were you reading?
My apologies, that's paragraph 16 at the top of that page.
Thank you.
And I say that principle was not abided by when one looks at the judgment in this case. And I would also make a brief point about the comment made by my lady. There is a human aspect, of course, in a judge deciding this sort of case. Within care proceedings, every failing that a parent has made in their life is pored over, often in excruciating detail. And the quid pro quo of that is that where there has been some evidence change, particularly where it's something of significance, a judge will take the trouble.
And I certainly, easily, as we all do, understand the point you are making. It goes wider than that, doesn't it? It's not just the parents who need to understand why the judge did what he did and what his analysis of the important relevant evidence is. It's other people. This couple might have another child. There may be more proceedings, and the judge who considers the case of any further child needs to know with some clarity what the situation was in November 2021 and the basis of the decision there. More widely, social workers, adopters, the child may need to know. These are not reasons for allowing the appeal, but it underlines the importance of clarity in any judgment as being an essential part of the process.
My lord, yes.
In a way, delivering a clear judgment is what it's all about. It's the product of the weeks and weeks of preparation and then presentation of evidence and then evaluation.
I would respectfully agree. My Lord, there is only one other point, and it's in relation to the March incident, which seems to have come up a few times. And I would only note a reference in page B79, which is my client's final statement. At paragraph 40 of that, he expressly denied making threats to kill or threatening anyone at any time. And indeed, he put the local authority to proof on that. He said, I would ask that they provide direct evidence regarding these suggestions, and I will respond to the evidence thereafter. So that point cannot legitimately be relied upon by the local authority, given that they did not seek to pursue a finding on that, and therefore nor could it be relied upon, in my respectful submission, by the judge in his judgment. He was limited to simply considering the fact my client had purchased cannabis someone in March, which is what my client accepted. To consider anything beyond that would be impermissible, unless I can assist the court further.
No, thank you very much. We're very grateful to all four of you, particularly you're both appearing pro bono, and I can't begin to understand how a litigant person could present this appeal. So they're no doubt grateful to you as we are as well. Shall we just discuss briefly? I think that although no one is going to give an extempore judgment today, I think it's sensible for us just to take stock and let you know the likely passage of events. So we rise for a short time, no more than 10 minutes.
Yes, thank you. Of course.
I mean, people on YouTube.
Right. Well, we are going to reserve our judgments. We're acutely conscious of the need for this case to move on, and we'll endeavour to deliver them as quickly as possible. They were circulated on the usual basis that you are encouraged to spot the inevitable and indeed deliberate typographical errors that we will put in for your entertainment, but not go any further in suggesting recrafting of the judgments. And there'll be no need to anyone to attend on the moment of hand down, and we hope you'll be able to agree an order that arises from the conclusions that we will have clearly stated in our judgments. Good? Nothing else? No? Good. Okay.